So welcome everybody to session 3 of today's forum on the regulatory, legal, and ethical aspects of cannabis. My name is Julienne Jagdeo, and I'm the sector manager in our health team here at Genome, and I will be your moderator for today's session. So as we've heard from our previous sessions, as well as we'll hear more about in our later sessions, that the legalization of cannabis has opened up many new opportunities across Canada and across a variety of sectors. But to get to this point, I'm sure you can appreciate that it wasn't just as simple as removing cannabis from the criminal code. As you'll hear from our talks that we will hear from in a minute, that regulation plays a critical role in helping to find that balance between maximizing the positive impacts of cannabis legalization while minimizing the risk of the potential social harms. So it is my pleasure to introduce our speakers for today. I will just go ahead and introduce them all at once together in the order that they are speaking in, so then they can just come up one after the other and do their talks uninterrupted. So our first speaker today will be Tom Shipley from Canopy Growth Corporation. And next we will hear from Jill Adams from RoadSafetyBC, followed by Lana Cully from Anambia, and lastly from Mary McFarlane from the Industrial Research Assistance Program at the National Research Council of Canada. Please give them a round of applause.
Hi guys. I want to start off by thanking you guys for having me here today. When I was invited to talk about legal and regulatory aspects, I said, wow, there's a lot of different topics I can cover. So I named the title and then later decided what I was actually going to talk about. So that's how I came up with hurdles and loopholes and then just explain some products. So the first thing I'm actually going to talk about is a very hot topic here in BC and across Canada, and that's about odor. Continues on the theme of terpenes that we have today, but instead of a positive context, this is more of a negative context because there are regulatory requirements for control of odor coming from buildings. And I think there's a level of legal and corporate responsibility in terms of these odors coming from buildings. Now, it's an incredibly challenging item to control because, of course, these terpenes are incredibly volatile. They're coming up into the air, and you can't filter all of that out of the air because our noses are just so sensitive to it. It's like trying to remove a smell from a sewage plant practically. So there's certain ways that you can mitigate the amount of odor coming out of a facility. And it's something that every single licensed producer faces, whether you're located in an agricultural area with maybe some residential nearby, or you've got a greenhouse close to an airport. You need to control these odors no matter what. So looking at the regulations, it says if you're producing cannabis indoors, you have to be able to control odor. So that's pretty straightforward. But what is the corporate responsibility? Well, it's a lot. You get a lot further in life having friends rather than enemies. So it's important to be a good neighbor to those who are around you. Some people do enjoy the smell of cannabis, especially the connoisseurs, but not everyone does. Some people claim they get headaches when they smell it and whatnot. So I think it's really important from a corporate liability point of view to be friendly with your neighbors, talk to them about what you're doing, the mitigation strategies you're putting in place, and really have an open dialogue with them so they know who to go to talk to if they are facing problems with odor that is reaching their vicinity. From a legal perspective, there's obviously the regulations that you need to maintain these odor controls in order to maintain your license. And Health Canada is very responsive to complaints that come in regards to odor. So they've had enough complaints now that they have a standard protocol in response to them. But beyond just the Health Canada side of things, there's also municipal laws and permitting that you have to deal with. And if you keep going through complaints or city council that's saying, you know what, you're not controlling your odor, you're not going to, not only for yourself, but for other licensed producers, it's going to be very difficult to actually get permitting to build a cannabis production facility in that area. So there's implications, both federal and municipal, as well as provincial, that can have an impact. Now, if we look at other industries that produce odor, farming is probably one of the most lax ones. Since we are an agricultural crop, you can call it a farm. And if you've ever been past a chicken farm or a pig farm, you can tell that it's very smelly. So there's also other industries like adhesives and sewage treatment where there's requirements for odor control, but there's a threshold that is acceptable. So ways that licensed producers control odor, carbon filtration is one of the go-tos, as well as oxidative degradation, such as hydroxyls or ozone, just to break down those terpenes. But if you start producing cannabis outdoors, hey, you no longer have to take care of odor. So the requirements, the permitting or the regulations say you can produce cannabis outdoors so long as it's not by a school or a youth center or one of those other types of areas, which means everywhere that really there's greenhouses and licensed producers are setting up today, they could have built an outdoor production facility, had no control over the odor during the cultivation processes. And so those strategies that are in place for enclosing the grow environment to prevent wind drift of that odor, as well as the carbon filtration and other strategies that are in place, they wouldn't apply to outdoor production. So I think that's a huge difference between indoor and outdoor, and obviously very it really emphasizes the corporate responsibility to choose these locations wisely, because the odor would be that much worse, especially with outdoor production. It's a very cost-effective method of production. So you see very large number of plants, huge plots that generate a large amount of odor. This isn't only true for medicinal cannabis, but also for hemp. And really from a legal perspective, it's very difficult to control odor outside, right? And that is obviously why it's exempt from the regulations, is that there's no real, it would be unreasonable to expect someone to feasibly control odor in an outdoor grow. All right, looking at cannabis products. A few really good things here that I completely agree with. When the regulations came out, there was this intention that there wouldn't be multiple inspectors going to a single site. So Health Canada said, you know what, we will inspect these facilities. There's no need for CFIA to come in and inspect these edible facilities. They took a bunch of regulations that are in the food regulations, such as implementing, hey, you're no longer allowed animals in your production areas, which of course no one was doing before, but they actually threw that into the regulations for the next rendition. And then a really another interesting aspect of edibles that's coming out is the fact that you're not allowed to use any type of addition of vitamins or minerals. So this is actually very interesting because in some cases you need to have enclosed containers that are free of oxygen, and in those cases you have to drop the pH. Now, ascorbic acid is great. It acts as an antioxidant, antibacterial, it drops the pH, but you can't use it because it's vitamin C. So you have to choose other types of acids to actually drop the pH, maybe citric acid instead of ascorbic acid. But there are exceptions to this. You could put it in applesauce or canned mushrooms. So if you guys think that THC canned mushrooms sound appealing, then I guess we're allowed. And then there's another section that says that it has to be shelf stable. That doesn't actually prevent us from freezing or refrigerating these products. It just means that they need to be shelf stable. So when you go into a cannabis retail store and you want to buy a beverage, it can be in the fridge, but it also means that when you take it home and you put it on the shelf, that it's also going to be okay. And I think one of the most critical elements that is completely correct is allergen labeling for the products themselves, as well as testing of the incoming materials. This is, if there's going to be adverse reactions from edibles, it's going to be allergens. And this is a really critical aspect that I think the cannabis industry needs to get right when the new regulations come out. And then let's take a look at some of the risk and ethics and possible loopholes surrounding this next generation of products, specifically cannabis extracts. So for all the different types of cannabis extracts, you're not allowed to put in an ingredient that can cause harm or would reasonably cause harm, with the exception of concentrates for inhalation. Now, these concentrates, they're specifically exempt, and I think the thinking behind that is that everyone knows that vaporizing, smoking, it can be harmful, and the existing data that's coming out from the electronic cigarette industry on PG and VG seems to indicate that while it might not be as harmful as smoking, there are still certain elements of harm associated with it. Now, with this is the idea that you can put in flavoring agents. So there's this one ingredient, I'll use an example called spill alcohol, which is actually a flavoring ingredient. And what's really interesting about it is it's not a terpene, but it's naturally occurring in a plant called the toothache plant, which is a local anesthetic. And why would an LP want to put this in as a flavoring agent? Well, it would reduce irritation in the respiratory tract on inhalation. Now, what is the potential harm associated with inhaling extracts from toothache plant? No one knows, but it then comes down to legal and corporate responsibility in order to ensure that whatever we're producing is going to be safe, because just because it's exempt in the regulations doesn't mean that you're free of any type of civil lawsuit. And that's it.
Hi everyone, thanks for your time and attention today, especially after lunch, talking about legal and regulatory. So my name is Jill Adams. I'm with RoadSafetyBC, which is a provincial government organization in the Ministry of Public Safety and Solicitor General. So we design and develop provincial programs for road safety, and then police and RCMP decide how to operationalize those programs. So actually last time I was in this room, I was here for a personalized medicine summit, so I recognize some of you from that. It's been a couple of years now, but I was on the application team for the digital technology supercluster, and I worked on the personalized medicine pillar for that, so there is some connection to that as well. But most recently, I'm leading a brand new team in RoadSafetyBC, and we're tasked with developing a drug-impaired driving program, similar to what we have for alcohol-impaired driving. So the impetus for the creation of this team was, of course, the legalization of cannabis, but we're looking at all impairing substances. It just didn't seem to make sense to build a program around one specific drug, leaving out everything else. So it's looking at all of them. And just to give you an overview of the regulations, so federally, a lot of this is managed by the federal government. So through the introduction of Bill C-46, peace officers were granted broader powers in managing impaired driving. And so most of you have probably heard about the Drager drug test 5000. It's been in the media a lot lately. That's an oral screening device designed to detect the presence of THC and cocaine, just those two. So to be clear, not opiates. There was a recent article about that, some of you have heard in the news, about poppy seed bagels. We can all eat poppy seed bagels, and it's okay. You can also drive after that. I can assure you that was not a scientific study, even though they have white lab coats on. So in approving the devices, the feds considered public comments and recommendations from an advisory body called the Drugs and Driving Committee as a part of the Canadian Society of Forensic Science. So they're comprised of forensic toxicologists and traffic safety experts, and they provide recommendations around oral fluid standards and evaluation procedures for everyone to follow. And in terms of provincial regulations, where we come in to support and strengthen these federal changes through Bill C-46, So the province introduced a zero tolerance regime for the presence of THC and cocaine in GLP drivers or new drivers in the graduated licensing program. And we're currently working on a few new drug-impaired driving, administrative driving prohibitions for drug-affected drivers. So that'll be coming in soon. And so just looking at the research briefly, drug-impaired driving is actually on the rise. It has been for a few years now, but alcohol-impaired driving has been declining. I think there's been a lot of public education and awareness, and a lot of people really realize that driving while impaired by alcohol is quite serious. But drug-impaired driving is more of a new area, so there hasn't been a lot of public education on that, and a lot of research still is needed to address it. And surveys also show that many drivers believe cannabis does not affect their ability to drive safely, and some actually believe that they're safer to drive after consuming cannabis. They're driving slower. But driving slower also means a slower reaction time in some cases with other impairing effects. So that's concerning. But it's also not surprising that drivers don't necessarily know how much they can consume and drive, because there isn't an actual quantitative amount. The government hasn't issued that, and probably will not, for reasons that many of you were talking about this morning. There's a lot of variability. So we don't have a specific quantitative amount or a time period after which from consuming. So there isn't really much guideline for people to follow. But similar to fatigue levels, we probably will never have that number to say, we just say don't drive with fatigue, but how fatigued is too much is kind of left to the person's best judgment. So with alcohol, there's a commonly shared guideline that most people kind of adhere to, that is people are generally able to drive safely after consuming one ounce drink every hour or so. So we all metabolize quite similarly. So that's a good guideline, but with cannabis, it's much more complicated to measure impairment levels. There's just so many variables in individuals, the people, as well as the plant, which we talked a lot about today. So THC affects users differently depending on use history. CBD and THC have much different effects from each other. Chronic users develop partial tolerance, and occasionally users tend to experience more intense psychomotor and psychological effects with lower amounts. There's different strains that have different effects. Some are stronger than others. Methods of consumption leads to differences in level of impairment and duration. Elimination rates are also non-linear, like they are with alcohol. So they can be going up and down depending on the time. And so it's not necessarily indicating higher impairment. It's just depending on when that person is tested. So important considerations for us. It does leave us with limited single criterion for determining cannabis impairment within a single time frame for all smokers or consumers of all frequencies and consumption types. It just won't be standardized in that way. So we can't easily replicate a program like we have for alcohol. It just doesn't make a lot of sense with all these considerations that we've noticed. So fortunately, we have other options. The oral screening devices are designed to detect presence and recent use, but not necessarily impairment. They can't be used to actually charge a driver alone. It's just one tool to screen initially. So from there, once formed reasonable grounds, police are able to use a very rigorous method of doing drug evaluations through a drug recognition expert, a DRE. And it takes quite a while. It's quite a test battery to go through, and so we're looking to find something that can get them through faster, and possibly at Roadside as well, because currently we don't have those evaluations happening at Roadside. They have to take the person back to the station and conduct a series of tests that way. So it's quite good and it's quite reliable. It just takes a lot of time. It can't be done at Roadside, and then that's what we're really hoping to achieve through this program. So that's where we're at right now. I think a lot of other countries, I've heard anyway, I was in Ottawa last week talking about drug-impaired driving indicators, developing national indicators, and they were saying there that a lot of countries are looking to us for these solutions for impaired driving. So we're excited because we're hoping to lead Canada, especially the team in BC. We're really looking for some innovative options. So if you have any ideas, I'd love to hear about them. Looking at digital technology to supplement the DRE evaluations and things like that. So the current status.
Okay. This is working. All right, so there's been quite a bit of an
business development for Nandia. And for those of you who don't know, we are Canada's largest cannabis dedicated analytical testing lab in Canada, I already said and fastest growing. We were founded actually on the grounds of UBC here in 2013, and we have grown rapidly over the last 6 years. We're currently at around 66 employees and adding weekly, sometimes daily. So we still have our location here on UBC campus, but we've also got space in this building viewed here. We currently have secured about 25,000 square feet in that building, and we're gradually moving into that. And just a few weeks ago, we actually bought a new location in Toronto. And so that group is being integrated within the Ananda team. So over time, we'll be able to offer our testing services out of both locations. But here I'm talking about intellectual property. So I do manage the intellectual property portfolio at Nandia, and I also have a background in managing plant varieties, which has a lot of relevance to cannabis. That, as Greg here was talking about in the panel about the plant earlier in the day. So often I think when people talk about IP or intellectual property, they automatically think patents, and patents are a big and useful tool to have in your portfolio. Essentially, in a nutshell, a patent is a country-specific, time-limited monopoly, if you get it granted, over the use of an invention. And generally, with respect to cannabis, it can be used for all different types of technologies. So it can be used to protect genes and the use of genes and gene variants in trait development and in breeding. It can be used to develop markers and methods for diagnostic tools or other platform technologies. It can be used for extraction technologies. It can be used for all manner of formulations and different types of inventions. So that's definitely an important one, but it's not the only one, and some of the other ones tend to get lost in the shuffle. Plant breeders' rights is a very useful tool as well. In Canada, you cannot, and in most countries, you cannot protect a plant or a plant variety with a patent. You can't protect the higher life form. So instead, you have this option called the plant breeder's right, which essentially protects the breeder from unauthorized propagation and sale of that genetic material. So even if you go to the store and buy an ornamental plant or now a cannabis plant that is protected by plant breeder's rights, you can't propagate from that and then sell. The third kind of important tool is trademarks. This is really used to protect brands. And unlike both patents and plant breeder's rights, it's not time limited. So as long as you are practicing the use of that trademark, whether it's to protect your company name, brand of a product, a slogan or tagline, sometimes even just a color and how you use that color in your marketing campaign, as long as you continue to use it, you have the right to continue to use that and exclude others from using it in, again, it's territory specific. And last but not least, I want to touch on trade secrets because I think that again, it's not a formal means of protection, but it actually can be one of the most powerful. Often, you'll hear it said that a patent or any form of intellectual property is only as useful as your willingness and ability to enforce that patent. And that's a very true statement. And if you don't have the resources to take a patent or all the way from filing through to issuing and then maintaining that patent over the course of its life, takes tens of thousands, possibly hundreds of thousands of dollars, depending on how that goes for you. You basically disclosed your technology in the process of patenting it, and then others can use it, and if you aren't willing to back it up and fight them for it, then it's gone. So, one of the things about cannabis that's really interesting is that essentially we have all manner of other industries to learn from, and sort of we can leapfrog a lot of the time and effort that it took to develop foundational resources like platform technologies and all these things, and we can accelerate things like the breeding pipeline and other inventions and get through that process much more quickly, which is fortunate. But typically, if you're looking at a nascent industry, you spend a lot of years, a lot of scientists toiling away in labs, building up a foundational knowledge, a lot of discoveries, and publishing papers and talking in forums like this about the research, and slowly you start to get a basis to create valuable uses of that technology. So basically creating, exploiting that knowledge to create commercial opportunities. And so after a certain period of time, you start to see patents starting to be filed, and over time that grows. So I took this example of AI, artificial intelligence, which you can see, so back in the 1980s, the research community started to get into that, and over time there's like this slower growth, and then around the year 2000, it sort of hit critical mass, and that started to skyrocket. And the patent filings definitely trails that, and about 10 years after that critical mass on the publication side, you start to see a critical mass and a skyrocketing on the patent side. So if we look at cannabis studies, and I took this off Twitter actually a few weeks ago, Nick Jacobus put this up, and you can see a similar curve of cannabis research over time, and now it's obviously skyrocketing. Obviously, the numbers on that y-axis are much smaller than we saw in AI, and obviously that's due to prohibition. We'll expect to see this skyrocket a lot more. However, what's interesting is I don't have a graph to illustrate this, but if you look at the actual patent filings that have happened over the last 10 years between this 2008 to 2018 period, within the World Intellectual Property Office, we've seen over 6,000 patent applications filed in that period of time, which essentially is mirroring exactly the growth of the publications. And so we're kind of in this new territory of IP and publication and the research that essentially fuels the generation of intellectual property kind of going at the same pace. And it remains to be seen exactly how this is all going to play out, because a lot of these patents have not gone through examination, and there's a lot of, because of the excitement in the cannabis space, there's a lot of people sort of preemptively patenting and trying to carve up space. And so I guess I'm here to say that there's a lot more to be seen in this space. There's a lot of opportunity in genomics as well as other aspects of cannabis. So even though there's all this patenting, doesn't mean that the space is closed off. It's just about you have to have even more strategic focus in order to create value out of the research that's going on. So I look forward to your questions.
Thank you very much to GWC for organizing this event, and I'm delighted to be invited to speak and tell you a little bit about regulatory issues around legalization of cannabis in Canada and somewhat abroad. Cannabis is one of my favorite topics. Although I'm not a user since my teens, I think. But I might be. Well, as we all know, the cannabis was legalized for recreational and adult use in Canada last year on October the 17th, historic date, when the Cannabis Act and the Impaired Driving Act, as I like to call it, came into effect. That was no small feat, actually, because there were 14 other acts that had to be amended to make way for this one. And that was a lot of work went into that, a lot of planning, a lot of people were involved with it. I know when I think of cannabis in Canada, I often think of Health Canada as being kind of the default organization. But Health Canada in the early days took on really an organizational role in the process of building a legislative framework. And there were a lot of other organizations that were involved that should be patted on the back too. Public Safety Canada, Public Health Agency, Stats Canada, Justice Canada, the Water Services Agency, RCMP, a lot of consultants were involved, and all the provinces and territories had representatives that were inputting information into creating this legislation. Skip a couple of these things in the interest of time. Health Canada was tasked with developing cannabis regulations that enshrine licensing in Canada. In the early days, that's up until October 17th last year, there were two types of licenses. One was for producers, and one was for what we call dealers. So if you were a licensed dealer, you were actually a lab that was allowed to test or do research. If you were a producer, then you were allowed to grow and sell or sell cannabis. After the 17th of October, the new legislation came in, and there's 6 classes of licenses now. One for cultivating, one for processing, for sale, and those all involve cannabis flower, dried flower, oil, extracted oils, seeds and plants. It doesn't cover anything to do with any kind of purified cannabinoids or synthetic cannabinoids. There are 3 other license classes. One of them is research, one of them is testing, so the laboratories, and another one is drug development. I'm not going to talk about drug development today because that has a whole lot of other regulatory approval overlaid over top of that. Cannabis is just a little part of it. I look at that as kind of the first wave of products that Health Canada has developed licensing around, and Canada has approved for growth and development and sale. The second wave is coming along very soon. It's being promised for the 17th of October this year, and that is for other methods of delivering cannabis to the body. So edibles, including beverages and food substances, extracts, so things that can be inhaled or ingested or concentrated, and topicals, so you deliver your cannabis through your skin. So that's just in the process. The proposed regulations have been issued, and Health Canada is waiting through the feedback that they've got in order to put that into place. I'm interested to see what happens because there's an election coming up right around that time, and not too much happens 6 weeks prior to the election, so we'll just have to see whether the feds can keep their promise up. There's another kind of wave of products coming along, and that's non-prescription drugs and natural health products. And Health Canada just made found a little quiet announcement about them going on to stakeholder proposing regulations for those. I think that's probably down the line quite a bit, probably at least another year or so, but we'll wait for those because that's where people can start adding cannabis to topicals and to nutraceuticals that everybody's dying to do right now. I won't talk about CBD because I think we're going to get into a great mire as we start there. Okay, so what's happening outside Canada? There's a lot of activity around the world in legalizing cannabis. 3 countries now are legal for recreational use. Uruguay was the first, Canada was the second, and now South Africa is people in South Africa are allowed to grow and grow for their own use. So the regulations in each of those countries are quite different. They're regulated for recreational use. There are, however, 46 countries right now and growing who allow cannabis for medical use. Some of them, a few of them, only allow pharmaceutical products to be used that be taken through clinical trials. So things like Sativex, Epidiolex, and a few more out there that are clinical pharmaceutical products. But the majority of them allow use of cannabis flower and cannabis oils. to give you just a couple of little examples of what's happening outside Canada. The U.S. is quite an interesting example because there's a little free-for-all down there right now. Cannabis is legalized in 34 states and 4 territories. 22 of them allow only medical use. The rest of them medical and recreational use. So the market is just blossoming down there. Both the legislative market and the illegal market as well is still in full swing there too. However, cannabis is illegal federally, and that's causing a lot of problems for people who want to work in that industry in the States. First of all, they can't import and export it very well. There's a little bit of that going on. Tilray has been able to export some cannabis for clinical trials, but that's unusual. Companies in the States cannot ship across state lines because that's federal jurisdiction. And raising money and getting a bank to take you on are also challenges too that the companies are facing. So, but there's a couple of things that indicate that at some time in the probably fairly near future, the situation will change. One of them is the Farm Bill that was actually put into place earlier this year. That allows for legal hemp production. Before now, it wasn't legal to grow hemp, even though a lot of people were. And also the US FDA has called for, it's actually, solicited comments on all aspects of cannabis as they relate to food and natural health products, safety and manufacturing and all sorts of things. They're actually holding a hearing tomorrow, which is really the first step along the pathway towards legal manufacturing of food and natural health products. So I see that as them putting in place the roadblocks for legalization. So I heard estimates of maybe it'll happen this year, I doubt it, but probably with the next administration it will happen. And one example from outside of North America that I wanted to talk a tiny bit about was Germany. There's a lot of activity in Germany right now. Cannabis was legalized in Germany in 2017 for medical use only. Germany has up until now not been producing its own cannabis, so they've been importing half of their supply from the Netherlands and half of it from Canada. So there's about 5 of our bigger companies who are active in Germany right now. In order to sell into Germany, you have to be GMP certified. You have to actually work with an importer as well. So all of these companies have actually bought up import companies and are running them as subsidiaries in Germany. So there's kind of a straight flow of cannabis from Canada to Germany. Cannabis will be grown in Germany in short order. There was a competition that was just completed in the last couple of weeks, I think, in which companies applied for the right to cultivate in Germany, and 3 awards were granted to companies. 2 of those were Canadian companies. One of them was a German company. So probably this time next year, they'll be looking at their first crops coming off the line for supply in Germany. It won't meet the whole of Germany.